everyone. Good morning. My name is Phyllis Fang, and I'm going to be moderating today's conversation. If you're completely new to Transcend, welcome. We're the platform that helps companies put privacy on autopilot, making it easy to encode privacy across your entire tech stack. So in today's session, we are going to be talking about preparing for employee DSARs under the CPRA. Joining me are Brandon Wiebe, Transcend's General Counsel and Head of Privacy, and Shaun Lichti, our Product Marketing Manager. Brandon and Shaun, I'll let you guys introduce yourselves.
Thanks, Phyllis, and hello, Shaun. I'm really excited to be with you today. As Phyllis said, my name is Brandon Wiebe. I'm General Counsel and Head of Privacy at Transcend, and really excited to chat about what I think is a thorny and sometimes challenging issue for a lot of businesses that I think would like to pretend that the employee exemption is not expiring, but unfortunately it seems to be. And so we are going to have to get prepared and figure out how to handle requests from workforce members. So excited to dive in on that today.
Awesome. Hi, everyone. I'm super excited to be here as well. I'm Shaun. I work in product and marketing here at Transcend, so kind of helping us and our customers understand what's going on from a regulatory standpoint. So if your guys' laptop screens have been anything like mine for the last couple of months, it has that Christmas tree of CPRA regulation markups with all the green and yellow and red strikeouts on it. So trying to make sense of these new regulations as they're changing and coming out, and help our customers understand what they need to do to be compliant in the new year. So really excited to chat with you more today.
Cool. Thank you both. Let's dive in and just get started. So quick overview on the, while I find my cursor, agenda for our session. We'll talk first about what the CPRA requires out of employee DSARs. Next, with these new rules, what are the new challenges that present themselves? And then finally, we'll wrap up with practical tips, guidelines, and ways for you guys to think about how to fulfill employee and applicant DSARs. All right, so let's dive right in. Brandon, why don't you kick us off? What does the CPRA require in terms of employee data rights? And do these new requirements really only apply to employees?
It's a great question. Let's start with a little bit of background. Just for, I know a lot of folks who are on here are probably familiar with this, but for those who are not, the California Consumer Privacy Act, CCPA, was passed back in 2018, and it took effect in 2020. And it imposed a wide variety of obligations that most of us are very familiar with on businesses that are processing consumer data. And it created a bunch of new rights for consumers, including the right to be notified of their data collection, the right to opt out of the sale of data, and rights to request access to, deletion of, and correction of consumer data from covered businesses. Little bit of a history back here is that CCPA was initially drafted as a ballot initiative. And you may recall back in 2018, it got enough signatures to get on the ballot. And that was what triggered the legislature to start working on a bill in order to negotiate to get that off the ballot, because the provision that was proposed was a bit of a mess and was not popular with industry. And so the legislature sat down and tried to negotiate this. They did it really quickly and passed CCPA, which got this ballot initiative taken off the ballot. But the result of that was, at the time, it felt like the legislature perhaps had not considered the scope of CCPA, and that as drafted, it would apply to a bunch of workforce information. So data that businesses are collecting about employers and job applicants and things like that. And so immediately after it was passed, there was a big worry that this was going to be untenable for a lot of businesses to be able to handle. So the legislature, shortly after passing CCPA, passed a bill called AB 25, and that exempted businesses in their role as employers from most, but not all, of CCPA's requirements with respect to workforce-related data. So under that bill, under AB 25, businesses in their capacity as employers, are still required to notify employees of the categories of data that are being collected. So there's this always been this notice obligation. And then in the event of security breaches involving employee data, there's an obligation to notify individuals, and you could still face statutory damages. But for the bulk of other CCPA obligations, AB 25 exempted businesses from having to do things like respond to access or delete requests from employees. This bill became known as the employee exemption to CCPA, and it had an expiration date. That expiration date was actually extended when CPRA was passed by ballot initiative in 2020. But it extended that exemption only until January 1st, 2023. We thought this past legislative session that there might be a possibility that the legislature would pass another bill extending the exemption further. But after this legislative session ended earlier this year with no bill, it became very clear that the exemption would officially die at the beginning of 2023. So that's where we are now. So practically, what does this mean? So starting on January 1st, employee data that businesses collect will be treated as any other commercial information under CCPA, and covered employees or employers will need to add employee and human resource data to their ongoing compliance efforts. Just as a little reminder, CCPA defines personal information very broadly to include information that identifies, relates to, describes, is reasonably associated with, or could reasonably be linked to a particular consumer household. So all of this data that had been exempted from these compliance obligations via AB 25 is now going to be subject to all of these CCPA and now CPRA obligations. This data likely includes things like employee contact information, insurance and benefits elections, direct deposit information, emergency contacts, and a whole variety of other stuff that we'll dig into in a little bit more detail. And while we're using the term employee as shorthand, to your question, Phyllis, the AB 25 exemption, it extended this exemption to all types of workforce individuals. So job applicants, contractors, emergency contacts, beneficiaries, board members, all of that information had been exempted from a lot of these obligations. And so when we're thinking about what has changed, all of this information will now become subject to these CCPA obligations and these CPRA obligations. What this means to get ready for these new requirements starting January 1st is that your notice of collection will have to be updated to describe all of these new rights that these individuals have. Businesses are going to need to stand up a way to honor the opt-out of sale or sharing of workforce data, and restrict the use of processing of sensitive personal information, which is a new right that was created by CPRA. And then the big focus for us today is that businesses will need a way to respond to employee requests to access, correct, or delete their data. So for this whole category of information that we previously have not really had to deal with or touch, we're going to have to stand up a lot of new processes to be able to honor these rights.
That's fantastic. Thanks for that overview, Brandon. I think really paints the picture of where we've been and what new challenges are coming, both in terms of data subjects, as well as the rights that they're granted. Brandon, what else should businesses be considering, particularly with respect to the requirement to respond to these workforce DSARs?
Yeah, so I think I'd highlight a couple things, just sort of top of mind before we get into the nitty-gritty details. The first thing I'd highlight is that setting up a process for managing workforce data requests is going to be a team effort in a way that probably looks different from how most businesses have handled consumer-facing requests so far. So while this is a new right in California, a version of this access right has existed under GDPR, and we can use that sort of to inform what this process might look like. What we've learned from that in GDPR is that one of the most common times that an employer may receive an access request will be in the context of pre-litigation or pre-dispute. So either a terminated or disgruntled employee or a job applicant may find that leveraging these privacy rights to get information becomes a form of free discovery early on in a dispute process. I think Employment Counsel is familiar with some obligations that have existed under the Labor Code in the past to provide employees who make a request with things like payroll information and some other information, but those are very limited compared to the scope of what's required under CCPA, which touches all personal information that an employer might hold on these types of individuals. So practically speaking, I think what this means is that to set up a process for handling employee access requests, you'll need to work really closely with your HR team, your HR system admins, and employment and litigation counsel should be at the table as well to ensure you are all fully aligned on how to properly manage and respond to these requests when they come in. The second thing I'll just quickly highlight is that we still don't know exactly what enforcement is going to look like in the new year. We know that the CPRA established the California Privacy Protection Agency as a new agency that's responsible for implementing and enforcing the law. They are charged with promulgating regulations and imposing fines for violations. We also know that the CPRA got rid of this mandatory 30-day cure period that had existed where the AG who was enforcing CCPA had to give businesses 30 days to cure a non-compliance issue before they could start an enforcement proceeding. That is now discretionary, and we don't know whether the CPPA will give folks those 30 days or not. They don't have to. And then the last thing to know as you're trying to assess like the level of risk and what this looks like for your business is that on a per violation basis, there are statutory damages of $2,500 for each unintentional violation and $7,500 for each intentional violation. So if you got in a situation where there were several violations for multiple individuals, you could see how those could potentially rack up. Enforcement by the CPPA will begin effective July 1st, but the obligations start for everybody on January 1st. So we will see what enforcement begins to look like starting in July, but businesses should really be thinking about trying to get compliant as quickly as they can. If they can't meet the Jan 1 deadline, at least putting together a good faith effort to try to get there as quickly as possible.
Yeah, definitely. That makes sense. Thanks for that overview. So I know we've been talking about the new challenges that this requirement presents, and you gave us a bit of a preview there, Brandon, but let's just dive right in because I know there's many more to cover. New rules mean new challenges. Let's dive in. Shaun, we already know that verifying identity is a critical part of fulfilling privacy requests under the CCPA. But with employee DSARs, there's additional layers to process. Can you talk us through some of that?
Yeah, definitely. So there's some more details here that we'll get to a little bit later, but at a high level, you have to scale the level of scrutiny you're applying during the verification process to match the sensitivity of the personal information that's at stake. That's what the statute says. So we really encourage companies to be thinking about making sure that there's enough rigor in that verification process to protect the more sensitive data involved with employee requests, usually just because of the nature of employee data that most companies hold. Additionally, it's important to remember that the statutes really encourage companies not to collect net new personal or sensitive information, like upload a picture of you with your driver's license during the, like, that's not the direction to go under the statute. They really want to see you matching against personal data that you're already holding to avoid net new collection and increasing the sprawl of data you have, rather than potentially getting ready to reduce it under a request. So look to use additional data you have, and maybe data out of your HR systems, and really make sure that you're scaling that verification to match the sensitivity of the data. Again, we'll get a little bit more into the details of implementation later on, but that's a high level of some of the new challenges here.
Okay, great. So compared to consumer privacy requests, these workforce requests often can reach a more sprawling, a more disorganized, scattered set of data. Brandon, can you tell us about what kind of additional data organizations need to consider with that?
Yeah, so I think this is going to be a unique challenge in the context of handling these workforce DSARs. There are a variety of areas where that immediately jump to mind when you think about where HR data might live or what it might include. So we listed some out earlier: employee contact information, insurance and benefits elections, direct deposit and bank information, emergency contacts, dependents, beneficiary dependents, resume and employment history, things like performance evaluations, even time punch cards, stock and equity grants, comp history. I think, we could probably sit down and come up with a pretty comprehensive list of what our typical HR records look like. And most of those types of records tend to be stored in an HR management system, or the HR team knows and has access to be able to pull most of that type of information without too much of a burden. But I think where this begins to get much trickier is when you start to think about all of the other areas of your business where personal information about a job applicant or an employee might reside. So think about things like emails or Slack messages between management as they're doing performance review and calibration, or a Slack channel that you set up to debrief an applicant's interview. Think about how many folks you emailed that job applicant's resume around to during that interview process, and how many applicants did you have for that role. And you can begin to see that this sort of personal information begins to sprawl across a lot of very unstructured communications channels. And compared to what a lot of businesses have done on the consumer-facing side, consumer-facing data sort of by default function tends to be a little more organized. I think for business analytics purposes, for marketing purposes, there's sort of a non-privacy reason to keep it very tightly organized and stored in structured databases. That's not always the case, but I think it tends to be a little bit more so than on the HR side, where I think a lot of businesses are going to find personal information sort of sprawled throughout very unstructured places. And all of that is going to continue to be subject to access and deletion and correction requests under CCPA. So I think this is going to be a particular challenge for businesses.
Okay, great. Yeah, that sounds like a hairy one. So I'm glad you brought it up. Let's dive in then into some tips and practical frameworks around how to effectively fulfill employee DSARs. So just to give a high-level overview, Brandon and Shaun will take us through these steps: creating a data inventory, writing your internal process policies, managing request intake and that verification that we talked about earlier, and then processing and fulfilling the actual requests. So let's dive right in. Shaun, I know that as with a lot of privacy tasks, starting with a data inventory is key. So specifically with the context of employee DSARs, what does that look like?
Yeah, we say it all the time, but you can't manage, you can't govern what you don't see and what you don't know about. And so with employee DSARs in particular, as Brandon just touched on, this is if possible more important than ever, just because of how sprawling the data is. It's not confined to the limits of a transaction or a product usage workflow like it might be on the consumer side. These people spend 8+ hours a day, sometimes for years, generating personal data in almost every system your company has. So we really recommend starting with a good overview of where the data is and understanding system owners. So it's easy, as Brandon kind of mentioned, to kind of check the box and be like, oh, a lot of this data is in HR systems, which is great. And you need to be mapping data in those systems and making sure you're integrating and looking in those systems. But it goes far beyond that. It can be role-specific systems like that they use in their department, whether it's a marketing tool, whether it's a development platform on the engineering side. And then probably one of the biggest generators of bulk data is all the common workforce productivity tools, whether it's email, messaging, video conferencing. These are places that people are constantly churning out unstructured data, and that often has personal and sensitive data mixed in and woven in with it, doctor's appointments on their calendars and emails about personal life events. And so it's really important to realize that legacy approaches to data mapping that may rely on like a static quarterly, if we're being optimistic, quarterly survey process or something, are really not going to catch this granularity of data. So looking for something that can adequately map unstructured data and that doesn't go out of date, that stays up to date rapidly, is really crucial to making sure you actually know what systems you need to be operating across to comply with an employee DSAR request.
Yeah, that definitely makes sense. And I think it just comes back to the breadth and the sprawl and the movement of all this personal data, right? Okay, so let's move on to internal policies. Brandon, can you talk us through why these internal policies are so important within the context of employee DSARs, and what about that process should folks be paying attention to specifically?
Yeah, so we I think touched on it a little bit earlier, but I think particularly in the HR or workforce request process, because the context of these requests can be very different from a consumer-facing one, it's really important for businesses to develop some internal policies ahead of time to understand who ought to be involved in handling a request. It's sort of as a first step important to identify who the key stakeholders in your business could be. And that probably at a minimum includes, an HR leader, employment counsel, security team, and privacy counsel. But then once you sort of assembled that group of folks who have a stake in how we handle or how we respond to access or delete requests, you got to work with those stakeholders to identify a workflow that really makes sense for your business specifically, and answer questions like, how robust do we want to be on authenticating a DSAR? For a deletion request, when do we want to put that request on hold because we believe there might be an applicable exception under CCPA? I bring that up in particular because under CCPA, there are some exceptions to when you do not need to comply with a delete request, or at least don't need to comply immediately. And those involve that the business is still in the process of completing a transaction, or you can't delete the data because you're upholding a legal obligation. Well, in the pre-litigation context or the dispute context, it may be that you have to put a litigation hold in place and preserve employee records. And so you cannot honor a delete request that comes in from a former employee or from a job applicant or something like that. So I think as a early step, it's important to get this team of stakeholders together and talk through these specific things so that you can draft a policy and understand how you are going to respond in different contexts before you get to the actual process of handling an actual access or delete request. So writing these policies and getting everyone aligned early on is going to be super important.
Yeah, definitely. I think we just always come back to the theme that privacy doesn't happen within a vacuum. And I think this is especially true with this new use case and this new type of data subject. Thanks, Brandon. All right, so we touched on verifying identity briefly earlier. Shaun, maybe you can take us back there a bit and share a bit more about how identity verification fits into that broader process of receiving a request.
Sorry, classic. How many years into this are we? And it's still, oh, you're on mute.
You're good. Sorry.
So we touched on the identity verification piece some. I'd just like to also kind of set that in the context of think about where and how you're ingesting these requests. Not only is this the experience that that the end user, the data subject, is going to go through, that's going to set the tone for their process of interacting with you in this context. It's also the first thing that a regulator or potential individual looking for enforcement or to contest this action is going to see. So really think about having a kind of a holistic privacy center where subjects can review policies, ideally are able to revisit and check on a request status, like where is it, how long is it taking? It may take longer than that period. Can I easily log in and see if a extension has been requested by the company fulfilling the request for me? All those sorts of things that smooth that process can really serve to make privacy not like a second-class citizen in your consumer, and in this case, employee experience process, but kind of really up-level it and make sure that's matching the rest of the work you're doing across your brand. And again, that also then gives you, it's not a static web form, and it gives you a single place to do things like authenticate requests using an OAuth credential. Remember, this is not just for former employees. This can be for current employees as well. So there can be authentication flows that make sense to have someone log in with a single sign-in type approach, which is better facilitated through a privacy center style ingest point rather than a static web form. So I think the high-level takeaway here is just make sure that it's not an afterthought of how you're collecting these, and make sure that it matches the experience you want to provide holistically for both your consumers and your employees.
Cool. Sounds great. Can you walk us through the process of processing a request? Let's start from the top.
Yeah. Now we're really into the meat of it here, where it starts to get fun, right? So this first one, determine what steps in the process should be manual or automated. So a fully manual approach, perhaps this is even the kind of approach that you may be using now for consumer requests, we really see not scaling well to the volume of data and unstructured data in employee requests in a fully manual sense. Early on, I know in the GDPR world, who have been having to fulfill these types of employee requests for quite a while, and initially were doing it in a very manual way. We heard these stories of companies spending thousands, if not sometimes tens of thousands of dollars doing very manual discovery, and it just doesn't work. So on the other hand, often some level of manual review is warranted due to the sensitivity of the information involved, the level of redaction. Brandon's talked about the potential for litigation here. So what we find is that finding the middle ground where you can use technology and automation to assist in the most time-consuming courses, the collation, collection, and detection of the data, and then surface it to you in a very intelligent way that can help you with those required mandatory manual review steps, is kind of finding that right mix. But ultimately, you have to find what works for your organization and the data that you have at hand. Once you've kind of made that determination, another thing to not forget, especially when it comes to making sure that you're fully and holistically discovering data that's responsive to a request, is to make sure you're keeping in mind the identifiers that you need to be using to seek and find responsive data. So let's say that during the verification process or the request intake process, you may be ingesting something like an email address from that end user. However, the data that's relevant to that employee that's sprawled across your systems could be associated with an employee ID, an internal company username they had when they were still at the company, an employee email address, potentially multiple employee addresses. I know at a former company as I was at, we migrated email domains twice, right? So I would really caution on looking at like one static identifier as like, oh, that'll do it. We'll just use this and go out and look on this identifier. Instead, think about the different systems that you're looking at and how employee data could be stored or associated in those systems. And again, going back to the first point around manual versus automated, you start to see why we suggest automating some of these more intensive and complex portions. So an automated DSAR system can ingest a single identifier point and then enrich it with a map of those other identifiers, so that when it goes to your connected systems to find responsive data, it's not just looking for John Smith at company.com, but it's also searching with those other identifiers. Now, speaking of going into those systems and looking across them, that's the integrations piece here. So we do recommend using integrations with a lot of companies and a lot of data systems. Honestly, this is the only way to do this at scale or to do this effectively. And beyond the time savings, we talked about the cost that can be associated with trying to do this manually without using API integrations to go in and pull data out. It's just a best practice from a sensitivity standpoint as well. So think about reducing the number of employees that need to be looped in when processing this sensitive data. Do you want to be creating potentially additional trails of data if you're doing this in a manual way? So, an email thread out to a bunch of employees, basically letting them know that there's a sensitive request in play for X former employee or X current employee and asking them to collect data is not ideal. So being able to essentially use integrations and API connections to have this data collected without it passing through a bunch of other hands, and then be at your fingertips for review, redaction, and discussions with counsel as necessary, is just a much safer and cleaner way to do this. And it's also highly auditable. Again, looking at this as free discovery and can unfortunately often be leading to employment litigation, making sure that you're doing this in a way that is minimizing the odds of something going awry is really important. So just overall, a lot of benefits to handling the discovery using technology to pull that data, to search and pull it, rather than manual processes.
Totally, a lot of benefits in relying on that, just between minimizing data trails, like you said, making it scalable, as we've seen this is a tedious process to fulfill. Great, thanks, Shaun. I know we've talked at the top a bit about redaction, the new challenge of redaction that this type of data brings. Now that we're in the meat of how to process these requests, Brandon, do you want to circle back on the redaction process, what this looks like in practice?
Yeah, I think thinking back to the volume and the disorganization potentially of HR data and how this workforce data presents itself in the wild, imagine an email chain, for example, with information about the data subject who's making the request on it. It also often will include a lot of personal information about other individuals in the business. And under CCPA, there's actually a private right of action for unauthorized disclosure of an individual's information without authorization. And this data breach private right of action is actually why we need to have such robust access controls when an access, or verification controls, I should say, when an access request is made. Because if we delivered an entire access report to the wrong person, that's effectively a data breach, and that can present some liability for businesses. The same is true in the context of these workforce access requests that might include personal information throughout the document, or the responsive document, or the that might be adjacent to the personal information of the requester. So the way to handle this is you really need to go in and make redactions to any personal information that is not relevant to the requester themselves, or is not the personal information of the requester themselves. There is not any regulatory guidance from the CPPA on how to approach this right now. And so there's a variety of methods. If we looked at GDPR, like the ICO has guided on, you can do things from, printing out documents and using a blackout pen to do your redactions, and do it totally manually, to doing sort of more programmatic redactions and scrambling that information or whiting it out that way. And so I think there are a variety of different approaches that you could take. ultimately what you're going to want to put in place is something that you feel confident is going to be a comprehensive way of identifying and fully removing and redacting other third-party personal information from any access request report that you're producing to an individual.
Got it. Great. Thank you. That makes a lot of sense. Okay, cool. I think this is where we've teed up our content, but we have a couple questions in the Q&A. So thanks guys for dropping those in. Please feel free to add more questions as you have them. These two might make sense to answer together, but let's just start with the first one. So first question is, can you please speak to the look back period in scope for DSARs?
Yep. It's a great question. So under the CCPA as amended by the CPRA, the look back period for access requests is 12 months. Because starting on January 1st, we are now to treat all workforce data the same as it would be the same as any other consumer information. That 12-month look back will apply to any new access request you get. So on January 1st, you will need to sort of search your records, your databases, wherever you have data stored for a period back to 12 months before supplying that access request to an individual.
Okay, cool. Thank you, Brandon. I think that our second question is similar, but we might have more to expand on, so I'll just read it out. How far back would you recommend searching the data systems in response to access requests? Would it be a limited time period? The cost of processing you're recommending can be significant. I think that's true. Shaun, do you want to? Yeah,
because it definitely obviously ladders off of what Brandon just said, and the explicit answer to that piece about the limited time period is the 12 months. I think to the broader question here, though, about especially the cost piece, right? Because that's something that every org is understandably sensitive to. And this ties back to that point we were talking about why using a technology like Transcend to handle that searching and processing portion scales much better. So instead of paying, for example, an employee or multiple employees to spend time going back and searching through all of these systems, you can do that via integrations. So again, for those of you, I know a lot of you here are familiar with Transcend. For those who aren't, the basic high level of the methodology there is just that we connect in via APIs across all your systems, your HR systems, your workforce systems, your email systems. We search Slack messages, email messages. So we're taking those personal identifiers that have been enriched from the end user and automating that process of discovering every piece of personal information related to that employee as it lives across your systems, and then surfacing it up in one place for review and approval before it goes out to that end user. And there isn't the cost doesn't scale in the same way when you're using technology to do that. It's much more efficient to be going out in addition to the other benefits we mentioned. So I think the short answer there is that this is why the technology is becoming more and more important, because as this exemption gets removed in the new year, it gets harder and harder to do this without having something to help find the data where it lives across those systems.
Yeah, definitely comes back to that for sure. Okay, third question. Thank you. Or actually, I think we've got a couple more. So let's just dive right in. So do you have a sample notice of collection or any best practices related to the notice? Brandon, do you?
Yeah, I think this is probably best handled offline. I would sort of, as a general non-legal guidance, since I am not the lawyer for any of the folks on the call, I would say I would steer away from sort of just using a generic recyclable template notice, and instead work with counsel that knows your business and is going to understand the scope of data that you have. What needs to be included in a notice needs to be very specific to the type of data that you're collecting and what you are doing with it. And that is unique and context specific, business to business, and something you'd want to analyze on sort of a case-to-case basis. So that may not be a very satisfying answer, but I don't know that we have a recyclable sample that we could send you. very happy to follow up, individually to talk more about that on a one-on-one basis, though.
Yeah, thank you. Makes sense. Are we hearing of employers who are creating a matrix of other laws or regs that control in terms of DSAR delete requests, such as payroll, tax, etc.? I think we touched on this briefly earlier, but Brandon, do you want to take this?
Yeah, I suspect that this is the approach that many businesses are taking. And this is why having employment counsel, litigation counsel, your HR team together as you're developing these internal policies and figuring out how to respond to requests is so important. Because there are a lot of other requirements, retention requirements that may control or may run counter to the access or delete obligations that you have under CCPA. And so you're going to need to sit down and sort of weigh those and ascertain how those apply to your business specifically. But I think a matrix is a fantastic way to approach that for your business. Yeah. Yeah,
definitely. Okay, I think we have time for one last question. So let's kind of bundle these last two together. Does Transcend search emails essentially when you can't delete information? I think, Shaun, do you want to take this?
Yeah, I think I see where we're going here. So short answer is yes. Unstructured systems like that are where our technology is at its best and most useful a lot of the time. So we do go through those kinds of systems and find the information. And often you're right. The answer is that you can't directly delete the information. But again, this is where and we have an interface within Transcend where the portion of the email with the personal information or the unstructured message with the personal information is surfaced. You can redact it for the end user, but you can also redact it internally. So remember, access requests are a big one, but employees also have the right to delete under CPRA and CCPA. So that may mean needing to go in and overwrite, or sometimes it's called like tombstoning, where you take for example, a Slack message that has a piece of personal information that's being deleted, and you overwrite it with something that says, this message was deleted pursuant to a request under CPRA by an impacted employee. All of that can be automated with Transcend, so that we're handling going in and doing the discovery, the redaction, and the overwriting or deletion within those unstructured systems like emails and Google Docs and Microsoft Office and all those places where that unstructured employee data is being created and lives.
Yeah, a lot of systems. Thanks for that overview, Shaun. I think just because we're running tight on time, we'll wrap up Q&A here. We'll follow up with, Britt, I see you have a question, and any other folks that drop in questions, we'll follow up with you all one-on-one. So thank you for asking. Sorry we ran out of time. I do want to just touch on one last slide. For any folks who are joining this webinar to claim your CPE credit with IAPP, here's an overview of instructions. You simply need to log into your IAPP account, go to the CPE submission form, and fill in information about this event. We'll certainly follow up too over email with these instructions so that you can be sure to go in and claim your CPE credit. So again, thank you everyone for joining us. I hope this session was an informative overview, gave you guys some practical tips, things to take back to your cross-functional org. And certainly for follow-up questions, or if there's any questions that come up outside of this webinar, we're here as a resource, so please reach out to us. Thank you all for joining.